Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I'd like to talk a little bit about the 245I in this video. You might be wondering why I'm coming out with a video on 245I when the issue, or the last time 245I was active and in the law, was April 30th, 2001. And that was a long time ago. It was over a decade ago. So how could it affect you now, and what relevance would it be to do a video, in 2012, almost 2013, on 245I? Well, first, I'd like to clear up some misconceptions about 245I, explain more or less what it is used for, and also how it could benefit you, and possibly how you might be under it, but you don't know that you're under it. So, first, let me give you a history of 245I and what it is. Now, basically, 245I came about when there was some laws that gave relief to people who were here illegally. The bottom line was, and I'll get into the specifics in a little bit, but the bottom line is that if you fell under 245I, and you basically, if you had a way to adjust and you could fall under 245I, then you would be able to essentially pay a penalty and then adjust to get the green card inside the United States. Alternatively, you'd have to leave, and then there's the 10-year bar, and there's waivers, and there's all kinds of stuff that happens if you essentially are not under 245I. So the fact that you have to pay a $1,000 penalty to remain in the U.S. and adjust is by far preferable to the alternative, which is leaving and trying to consular process. So 245I actually came and went two different times, meaning it was a law at one point, then it expired, and then it was renewed again with some different provisions, and then it expired. But it's grandfathered, meaning if you fall under it or a derivative falls under it, then you are able to take the benefits from 245I in order to be able to adjust status to get the green card. So a little bit on the history. The first time where it had to be filed was right around January 14th, 1998. And what I mean by it had to be filed is you had to have either an I-130, which is a family-based petition filed, or an I-140, which is an employment-based petition, and it just had to be filed. Now, it had to be bona fide. So obviously you couldn't file, for example, an I-140 with a fake employer in order to get under 245I. You couldn't file an I-130 with, for example, a fake spouse. And it had to be bona fide at the inception. So, for example, I'll just give you an example. If a lawful permanent resident filed an I-130 petition for his married son, then, while they may have received a receipt notice, ultimately it would get denied because there is no preference for that category. So that's what I mean when I say it had to be bona fide at the outset. It doesn't matter that ultimately it got denied. I mean, for example, they do a marriage petition, and before everything goes through, the marriage falls apart, or there's a sibling petition, before everything goes through, the petitioner dies. I mean, there's other things that can be done to resolve that, but more or less it's not so important that it doesn't get approved. It's only when it's filed. And in the employment-based arena, you could have had a valid employer petition you, and then they went bankrupt, or they, after 5 years of waiting, they said adios, and they didn't want to deal with you anymore. So that's okay. You're still under 245I if it was properly filed. Now, if you were under the 245I as of the January 14th, 98 date, then there's no other requirements, basically, that you would need in order to ultimately fall under an adjust status. Now that came and went, and then the last one was a filing that had to be done by April 30th, 2001. So if the, again, I-130 or I-140 employment-based petition was done as of April 30th, 2001, then you'll fall under 245I if, and this is a big if here, you had to be inside the United States on December 20th, 2000. So if you just happen to go to Mexico to Tijuana and have a nice party that day, and you weren't inside the United States on that day, then you don't qualify. So basically, when filing an adjustment under 245I and trying to get the green card, of course, you have to show reasonable evidence that you were here on that day, and that can be shown through payroll records, Social Security records. It can be shown by declarations, affidavits, rental statements, receipts. I mean, there's all kinds of ways of showing. Obviously, a lot of people won't have an exact evidence on that exact day, but you can put the picture together so that it's more likely than not that you are and you've satisfied the burden that you were physically present. So let me tell you, now given that, let me tell you more or less how procedurally it works, and then we'll get into some issues of how you might be under it and you don't know, and so forth. So the way it works is, let's say that you're married to a lawful permanent resident, and the lawful permanent resident files an I-130 petition for you, and boom, it gets in on April 30th, 2001. And let's say the country you're from, is the Philippines, and let's say it takes 5 years or so to become current. So now, let's say that it's 2006 or 2007, it's current. You're able to then file the adjustment application. Again, you pay the $1,000 penalty fee and the normal other fees, and assuming all else is good, you adjust your status and you get the green card. Okay, same thing with employment-based. You wait till it becomes current, and then you file, and then if everything else is smooth, you get lawful permanent residency. Now, there's some misconceptions with 245I that you need to be aware of. First of all, some people think, actually a lot of people think, that if you're under 245I, you cannot be deported, that you cannot be put in deportation proceedings, and that you are safe from any deportation, and that's not true. There's nothing in the law that says that if you're under 245I, you're untouchable by immigration, that you can't be deported, and that you can just wait it out for all the years until the visa number becomes current. I mean, for example, if you're a fourth preference petition, that actually is a very long wait, sometimes up to 20 years. So, that's if you're thinking that you're safe from deportation, that's like having a petition filed on 2001 and thinking that you can be in the United States without being touched until 2021, and it just doesn't work like that. So the way 245I is if you happen to be in the U.S. and you happen to be able to file an adjustment when it becomes current, then you can file, pay the penalty, and adjust. Now that doesn't mean, for example, if you get put into deportation proceedings, that it can't be fought. I mean, realistically, if I get a client that, let's say 4 years away from a visa number becoming current, and they get put in deportation proceedings, I can certainly fight it for years, and it can go up on appeal and up to the circuit courts, and then ultimately, years later, when the visa number becomes current, we make a motion to remand it back down, or a motion to reopen, depending, and then we go from there. So that's how that works. So don't be under the false impression that you can't be deported. Now, secondly, 245I doesn't alleviate the other grounds that might exist of inadmissibility. So, for example, let's say you have a crime, of possession of marijuana or whatever, and that makes you inadmissible. Well, if you have to do a waiver, And if a waiver is available, you still need to do the waiver even if you're under 245I. And there's one case actually that just came out in the Seventh Circuit, unfortunately, that basically said if you have made an illegal reentry twice, you actually fall under another area of law. And this particular person brought a lawsuit to actually brought a lawsuit saying that they qualify under 245I and therefore that other provision shouldn't apply, which essentially makes them permanently inadmissible. Well, the reality is the Seventh Circuit said that's not true. That other provision trumps 245I and they're unable to adjust. So there are some issues still going on with 245I that you have to be aware of, but again, there's always ways of fighting it if you happen to be in such a position. Now, let me tell you that there are derivative beneficiaries of 245I, and this is where I was saying previously that you might fall under 245I and not know about it. So for example, somebody comes into my office, they're getting married, they came to the country illegally, so they don't normally qualify to adjust status in the U.S. So normally, they would have to leave the country, they have to do the waiver of the 10-year bar, there's all kinds of issues. And bottom line is, if you can adjust in the U.S., that's where you should adjust. You would always want to do that versus leaving the country. There's a lot more control in the U.S. We can appeal and do motions. I mean, we can do that if you leave as well, but we have a lot more power and control inside the United States. So the first thing I ask is, well, where are your parents? Where are your siblings? And many times they'll say, well, the parents came, a lot of years ago, it's just they never filed for them. Or, there's an uncle that came many years ago and he never specifically filed for him either. So then I go into, well, what did your parents ever file for? Who filed for your parents? And a lot of times they'll say, well, uncle, aunt filed for the parents 20 years ago and they're still trying to adjust and, this and that. And so I go, well, did they file for them before April 30th, 2001? And many times the answer will be yes. And if that's the case, then what that means is that you, being the client in my office, who is the son or daughter of the parent who had a petition that was filed before April 30th, 2001, you are a derivative beneficiary. And because of that, you're under 245I. Even though you never had a petition directly filed for you, even though nobody ever directly petitioned you, you're under 245I. And then what I can say is, well, then, assuming, let's just say this is a marriage petition, well then, you can adjust status in the U.S., you don't have to leave, you pay the penalty, and you're under 245I. And that applies for employment also. If you're a derivative beneficiary under 245I and you come in my office and, let's say you have nothing, you have no way of really adjusting, I say, well, where do you work? What type of work do you do? And I say, well, I work at XYZ and they do want to help me. Well, then we can file an employment petition, do a perm, and then once you're ready to adjust, again, because you're a derivative beneficiary, then you're under 245I and you can file. So that's a great benefit to 245I, and that's why, one reason why this video is appropriate at this time, because there's still people who are under it that don't know they're under it, and again, they're able to adjust status in the U.S. without having to leave. Now, with 245I, there's a couple issues, other issues that I'd like to discuss, that I'd like to give you clarification upon. Now, when you're doing the adjustment, of course, you're going to have to file the supplement, and again, you have to show that you do fall under it. But the one thing about 245I is, let's say that one petition was filed under 245I, whether you're the derivative or the primary, and let's say that petition fell through and you didn't get the green card or never even had an opportunity to apply for it. Well, once you're under 245I, you're under it. And then you can file another petition with another preference, another category, and still, when that becomes current, you can adjust status under the 245I under the second petition, even though the first one didn't work. And that's basically how 245I will work. And so when you go to the attorney's office, and again, you can come to my office, or do a Skype consultation, telephone consultation, whatever, and I'll go through all the facts to determine whether or not you're directly under 245I, whether you're indirectly under it, whether you're a derivative beneficiary, because we want to do everything we can to try to get you under it. One other issue, some officials have ruled that if you do apply under 245I, you actually apply for adjustment and it's denied, that you can't apply for another 245I, that it's like one shot at the apple and that's it. I've had cases go both ways, and what I do, obviously, is we want to fight for it. So if you've already applied and been denied for whatever reason, then we can file another one, and I would cite all kinds of laws as to why you would qualify for the 245I and why it should go forward. So hopefully I've cleared up some of the issues with 245I, how it works, procedures, and so forth. And if you have questions or want a consult, just let me know. I'll be happy to help, and we'll go from there. Okay, more on the coming videos.